Hi folks, my name's Ron Bishop from Timaru, New Zealand, and I'm talking about one of the biggest industries in the world this morning, called the employment law. Every country has employment laws, and I'm talking about the New Zealand employment law. I believe the New Zealand employment law needs attention, real bad, because there are many people who are suffering as a result of the employment law in New Zealand. And I'm presenting my case today, my counterclaims. I made several counterclaims, and I'm reciting my counterclaims online. The counterclaims I made have been rejected by the New Zealand employment authorities, and I'm putting them online, and I'm letting people have a see what happened to my business and why it happened that way. What most people would consider to be a very simple procedure, that if someone is dishonest, found to be dishonest, and you dismiss them, that would be the end of it. But it's not so in the New Zealand employment law. We dismissed a woman on the grounds of dishonesty, and the Employment Relations Authority said she was not dishonest, and the Employment Court said she was not dishonest. So this case is a lot about dishonesty. Who was honest and who wasn't honest. So I'm going to start my story this morning by reading to you from the determination that was made by the Employment Relations Authority. And I'm reading about a counterclaim that I made at that hearing. Mr. and Mrs. Bishop counterclaim Miss Bennett in the sum of $42,653.99 is set out below. Unauthorised deposits made into Data Communications bank account $5,273.88. Rental of office premises for personal business $2,000. Use of power, telephone rates, etc. $1,001.94. Refund of wages for time spent on personal business $3,765.61. A refund of holiday pay time spent on personal business $315.83. Refund of holiday pay paid but not due $342.65. Refund of after hours wages $356.25. Unpaid GST to Inland Revenue Department incurring penalties $4,020.20. Compass account for incorrect documentation $4,797.89. Known missing stationery items $93.61. Stationery items purchased by non-employee, the applicant's son, $320.75. Cost of audit fees $352.28. Cost of photocopying wage book sheets as promised $13.20. Our costs incidental to this administration of these actions $5,000. Compensation for causing worry and stress within the family $15,000. Total of $42,653.99, and that was our counterclaim against Miss Bennett when she put a personal grievance claim against us. The authority member of the Employment Relations Authority in this case was Helen Doyle, and we laid a complaint after Miss Doyle gave her determination, and I'm going to be reading a letter to you now that I wrote to the chief of the Employment Relations Authority. We wish to make a complaint about your Christchurch Authority member Helen Doyle. Our first complaint relates to the timing of the determination. Most law firms close over the holiday season, and to expect us to meet the deadline of the 18th of January 2010 is totally unreasonable. Other complaints is about the way in which the authority member has totally ignored all our evidence of dishonest, abusive and physical aggressive behaviour by the applicant. Privacy Act. We believe that we provided enough evidence to convince the member of that the application allegedly committed a breach of our privacy by opening a bank account in our name without our permission after only 2 days in our employment. The ERA member states that it was our fault for not cancelling the account after it had been unlawfully opened. Fraud. The applicant obtained a life insurance agency in her own name and used our trading name, our postal and physical address, our office, our time and our bank accounts to run her part-time insurance and investment broking business, and she's still using our trading name 16 months after her dismissal. The applicant wrote out a cheque from our chequebook and signed it without having signing authority. The applicant purchased foreign exchange from the proceeds of our bank account without our authority. The ERA member has ruled that all this behaviour is not dishonesty. Income Tax Act. The applicant filed false GST returns to the IRD and the ERA member has ruled that it was not our accountant's. I'll read that again. Income Tax Act. The applicant filed false GST returns to the IRD and the ERA member, Helen Doyle, has ruled that it was our accountant's fault for not picking up the crime after it had been committed. The applicant deducted withholding tax while working for us because she was also self-employed. The ERA member ruled that this was perfectly okay because her accountant had told her to deduct 20% instead of PAYE. The ERA member has stated that it is not part of her job to investigate the applicant's relationship with the IRD. Holiday Pays Act. The applicant committed an offence by paying herself holiday pay and sick leave which was outside the Holiday Pays Act guidelines. The ERA member has described this behaviour as somewhat unusual but not an offence worthy of dismissal. Theft. The applicant and his son, who is not employed by us, both purchased goods in our name without our permission. The ERA member has described this activity as unwise but not dishonest. The applicant stole goods from my private office, took them home and has never returned them. The ERA member took the view that because she attempted to pay for the goods after they were stolen, that was acceptable and no reason for instant dismissal. The applicant failed to return the office keys and post office keys because her partner advised her to hold on to them as ransom, but this evidence was ignored by the ERA member, who found this type of blackmail acceptable. Violence in the workplace. The applicant was dismissed by one of our previous employers because she verbally abused and assaulted one of her workmates. The applicant was then successfully claimed compensation from her past employer in the knowledge that she can get paid compensation if she uses violence in the workplace. She did the same with us. I believe this has been one of the motivating factors in her wanting to dismiss her. I'll read that again. I believe this has been one of the motivating factors in her wanting us to dismiss her. The ERA member has turned a blind eye to such behaviour and is rewarding her for doing it. The investigation hearing. While I was addressing the ERA member, the investigation hearing, the applicant, her partner and her solicitor were laughing and having a little conversation of their own, and the ERA member failed in her duty to call the meeting to order. Police involvement. We first contacted the police after we had been told by a previous employer that the applicant had been dismissed by them for dishonesty, one of which was for alleged forgery. We have made several statements to the police, and all this is that is all recorded on our file number. We have made several statements to the police, and all recorded on our file number. The police told us they cannot lay charges against the applicant while the case is before the Employment Relations Authority. The Employment Relations has awarded the applicant $9,000 in application for hurt and humiliation because we were forced to go to the police and make inquiries with other people. Costs. The ERA member has reserved his decision on costs, which means we do not know how much, if any, of the applicant's costs we have to pay. Unless we know the full costs of what we have to pay, we cannot decide if it is worth defending the employment court. All hope of recovering our costs have been lost when the ERA member dismissed all of our counterclaims in its entirety. Summary. Attaches a list of things that the applicant did to us. My wife and I are both in our 70s now, and I'm not sure that we have the strength left to continue to fight against a system that seems to be designed to encourage dishonest behaviour. We have just a few days left to get much needed help with our case at a time when there is no legal advice available thanks to the timing of the ERA member, Miss Helen Doyle. The reason we are writing to you is because we have run out of ways of defending ourselves, and we are hoping you may be able to help. Yours faithfully, Ron and Margaret Bishop. On the 15th of January 2010, we also wrote to the Chief of the Employment Relations Authority with another complaint. And this is what I wrote. I would hereby like to make an official complaint to both the Department of Labour and the Employment Relations Authority in relation to an employment mediation conference held on the 18th of November 2008 and the subsequent investigation meeting conducted on the 29th of August 2009 by the Christchurch member for the Employment Relations Authority, Helen Doyle. Meeting procedure. We wrote to you on the 6th of January regarding our concern about the timing of the determination made by Helen Doyle, preventing adequate time to seek adequate legal advice in response to her determinations, as well as her lack of consideration of the evidence provided by us for the hearings. Since the complaint was admitted to your office, I have received some additional legal advice in regard to courtroom meeting procedure, and consequently would like to raise some extra concerns in relation to our case. My concerns are in relation to irregularities in the way the above-mentioned meetings were conducted. These concerns are: there was no scribe present to record what was said at both meetings, thus making it impossible to respond to comments made during the meeting. Mediation meeting. The applicant and her solicitor walked out during the mediation meeting without being excused and did not return to complete the negotiations with the respondents, making it impossible to address any complaints effectively. Investigation meeting. The applicant invited a witness, her partner, to attend the investigation meeting, who was permitted by the member, Helen Doyle, to remain in the room for the duration of the hearing. What was more concerning, however, was the witness was free to respond to questions directly at the applicant and unhindered and without being addressed. Number 4. The witness also made confessions during the meeting that the keys to the respondent's office and postbox were held by him and his partner as for ransom. This was not considered by Helen Doyle for her determination. Finally, it has been brought to our attention that our case was weakened due to our procedural ignorance. It appears as though procedural irregularities have occurred on a number of levels, and therefore we would like to have our complaints addressed and our case reconsidered. We look forward from hearing from you in due course. Ron and Margaret Bishop. And copies were sent to the Prime Minister, Mr. John Key, the Minister of Employment, Honourable Paula Bennett, and Honourable Kate Wilkinson, Minister of Labour, and Joe Goodhue, the Rangatato Member of Parliament. When I made this complaint, I sent with it a letter to whom it may concern. I addressed it to whom it may concern because there's many people going to be reading it. This is the brief details of a claim against our former worker. To the Employment Relations Authority. The Employment Relations Authority has awarded our former worker the total sum of $12,924.14 in compensation, claiming she was unjustifiably dismissed from her position as office manager of our business. In her decision, as sole judge, the Employment Relations Authority member took the view that our former worker had been dishonest and that her violent and abusive behaviour did not justify dismissal. As sole judge, the Employers Authority member described our former worker's behaviour as somewhat unusual and unwise but not dishonest. The following is a list of events that took place during our worker's employment with us. Our worker did not disclose to us that she had been dismissed by her past two previous employees for dishonesty and physical violence in the workplace. Number 2, she did not disclose that she had made a claim for unfair dismissal with a previous employer. Number 3, breached our privacy with the opening of a new bank account in our name. 4, deceived us by arranging an insurance agency from our office which included our name. Which excluded our name. Number 5, not disclosing to us that she was an insurance on commission share. Sorry, I'll read that again. Number 5, not disclosing to us what our insurance commission share would be. Number 6, use of our office to sell insurance policies as an independent insurance broker. Number 7, use of our bank account without our approval to deposit her life insurance commissions. Number 8, use of our bank accounts to withdraw her life insurance commissions. Number 9, not paying income tax on insurance commissions she withdrew from our bank accounts. Number 10, using our checkbook to write out cash cheques and signing it herself. Number 11, taking the same cheque to the bank and cancelling it. Number 12, using the cancelled cheque to purchase foreign exchange without our authorisation. Number 13, stealing the life insurance agreements from my personal office. Number 14, switching from PAYE on tax code M to with the 20% withholding tax. Number 15, not disclosing to us her part-time employment status for taxation. Number 16, incorrect calculation of holiday pay, breaching the Holiday Pays Act. Number 17, incorrect calculation of sick leave, breaching the Holiday Pays Act. Number 18, filing false GST returns, breaching the Income Tax Act. Number 19, making agreements with telemarketers that were unrealistic. Number 20, claiming for after-hours calls without providing a schedule of who was called. Number 20, purchasing a toilet seat without permission and adding the cost of her wages. 22, charging personal stationery items in our name without our permission. Number 23, charging of stationery items in our name by her son Scott Bennett without our permission. Number 24, purchasing stationery items surplus to our requirements. Number 25, violence and bad behaviour in the workplace. Number 26, theft of stationery items from my personal office. Number 27, attempting to pay for stolen goods with a joint-owned checkbook. Number 8, verbal and physical violence in my office. Number 29, slander about my mental state of health. Number 30, removing her personal items from our office and demanding that they be replaced. Number 31, refusal to accept a new position in our business. Number 32, claimed she was going to leave once she found another job. Number 33, claimed her partner was going to make a personal grievance claim after he was made redundant. Number 35, instant dismissal. instant dismissal. And this was a woman who the judge said, the employment court judge and the Employment Relations Authority member said was not dishonest. I rest my case, Your Honour. Bye-bye.